The judge leaned forward, carefully examining the documents in his hands, a faint but unmistakably ironic smile playing at the corners of his lips. The murmuring in the courtroom faded into silence, as all eyes focused on the man who had once commanded the most powerful office in the world. Then, with a slight shrug and a suppressed chuckle, the magistrate raised his gaze. "Donald Trump, the former president who believes himself above the law," he declared, his voice dripping with sarcasm. To the left of the courtroom, the prosecutor allowed himself a confident smirk. To him, and to many others in attendance, this was no ordinary trial. It was a historic reckoning. The packed gallery testified to the significance of the moment. Reporters scribbled furiously in their notebooks, camera flashes flickered without pause, and hushed whispers filled the air. The world had already made up its mind about how this story would unfold, long before the first argument had even been made. Yet Trump remained still. Seated at the defense table with his arms resting on the polished wooden surface, he displayed no signs of frustration, fear, or even impatience. His expression was unreadable, calm, unwavering. He fixed his gaze upon the judge, unblinking, unshaken. If he felt the weight of the charges against him, obstruction of justice, election interference, financial misconduct, he certainly did not show it. The judge's expression widened slightly, amused by Trump's silence. "I hope you're ready, Mr. Trump," the judge continued, his tone bordering on provocation. "This isn't a campaign rally, this is a court of law." A restrained chuckle rippled through the chamber, but Trump didn't react. His eyes remained locked onto the figure presiding over the trial. And then, just as everyone assumed he would remain silent, he finally spoke, his voice calm, low, deliberate. The effect was immediate. The prosecutor's smirk faltered. The scattered laughter died down. Even the judge, who had thus far maintained a relaxed demeanor, seemed to straighten ever so slightly. Whatever Trump had said, it had cast a sudden stillness over the courtroom. No one dared to break the silence. The prosecutor seized the moment, adjusting his tie and stepping toward the jury. His movements were deliberate, his voice steady and commanding. "Ladies and gentlemen," he declared, "we are here today because a former president believes himself beyond the reach of justice." He gestured toward Trump before turning to the judge. "The evidence is undeniable. The defendant has repeatedly ignored subpoenas, obstructed investigations, and shown blatant disregard for the rule of law. No citizen, no matter how powerful, is above accountability." The judge gave a slow nod, signaling his agreement with the prosecutor's argument. There was even a hint of a smirk on his lips. "Mr. Trump," the judge addressed him once more, his voice firm. The courtroom, though vast, suddenly felt much smaller, suffocated by the tension in the air. This was more than a legal proceeding. It was a moment of reckoning for a man who had built his career on defying norms, pushing legal boundaries, and challenging the institutions meant to hold leaders accountable. The spectators leaned forward, eager to witness the next move in this high-stakes battle. Journalists gripped their pens, knowing that no matter the verdict, this trial would be remembered in history books. The prosecutor pressed on. "We've seen this pattern before. Powerful figures who believe they can bend the law to their will, who treat the justice system as just another political battlefield. But today, this courtroom serves as a reminder that no one, not even a former president, is beyond the reach of justice." Still, Trump remained unmoved. His silence was not defiance, it was calculation, the mark of a man who had weathered countless legal storms before. If he felt the weight of the accusations, he did not let it show. The judge, recognizing the gravity of the moment, leaned forward slightly. "Mr. Trump," he repeated, his voice carrying the weight of authority. "Do you have anything to say in your defense?" The room held its collective breath. Then, finally, Trump spoke again. His voice was steady, his tone unmistakably familiar, neither pleading nor defensive, but confrontational. "This is a witch hunt," he said. "A sham trial, orchestrated by the radical left, the fake news media, and those who want to see America fail." A murmur spread through the courtroom. The judge's expression flickered. Was it frustration? Annoyance? Perhaps both. The prosecutor clenched his jaw, realizing that what had begun as a straightforward case was becoming something far greater. A battle for public perception. The prosecutor took a deep breath, pressing forward. "Mr. Trump, with all due respect, this is not about politics. This is about the law. Do you deny that you obstructed a federal investigation? That you attempted to overturn a legitimate election? That you used your power to pressure officials into breaking the law?" Trump smirked slightly, shaking his head. "I did what was necessary to protect this country from fraud. The real crime is what they did to me, what they did to the American people. And history will prove me right." The judge tapped his gavel lightly, restoring order as murmurs of agreement and outrage filled the courtroom. Mr. Trump, this is a court of law, not a campaign speech. You are expected to answer the charges brought against you. The former president leaned back in his chair, crossing his arms. I understand the game being played here, he said. But the American people see through it. They know this isn't justice. This is persecution. The prosecutor sighed, then turned to the jury. Ladies and gentlemen, I ask you, if any other citizen had done what this man has done, would they not already be behind bars? The rule of law must stand, regardless of power, wealth, or influence. If we allow one man to defy accountability, we set a dangerous precedent for the future of this nation. The weight of his words hung in the air. The judge glanced at Trump once more before calling a recess. As the courtroom emptied, one thing was clear. This trial was more than just a legal battle. It was a fight for the soul of a nation, a test of whether justice could truly prevail in the face of power. And as Trump stood, adjusting his suit, he knew one thing as well. This was far from over. The courtroom remained silent for a long moment. The judge's gaze was fixed on Trump, his fingers lightly tapping against the polished wooden surface of his bench. There was something both calculated and amused in his expression, as if he had expected exactly this kind of performance. The prosecutor, on the other hand, was visibly irritated. He had seen Trump command a room before, on debate stages, at rallies, and in televised interviews. But here, in a court of law, it was different. Or at least, it was supposed to be. But Trump had a way of bending the rules without ever seeming to break them. He had a way of turning any situation, no matter how damning, into a battle for public opinion. And right now, despite the seriousness of the charges against him, it was clear that he was still playing to the audience. The prosecutor took a slow breath before speaking again. Very well, Mr. Trump. If that is your position, then let's move forward. We will now proceed with witness testimony. A bailiff stepped forward, calling the first name on the list. Ms. Catherine Reynolds. A woman in a gray suit stood from the gallery and walked toward the witness stand. She was composed, her posture upright, her expression neutral, though there was a flicker of something in her eyes. Uncertainty? Hesitation? Whatever it was, she quickly masked it as she took the oath and sat down. The prosecutor approached, his voice measured and professional. Ms. Reynolds, please state your occupation for the record. I was a senior election official in Georgia during the 2020 election. And during your tenure, did you have any direct interactions with the defendant? A beat of silence. Then, with careful precision, she responded, yes. I received a phone call from Mr. Trump on January 2, 2021. Trump leaned back slightly in his chair, arms crossed. The mention of that phone call was expected. It had been at the center of one of the key allegations against him. The prosecutor nodded. Can you describe the nature of that conversation? Reynolds inhaled slowly. The president, Mr. Trump, expressed concerns about alleged voter fraud. He stated that he needed us to find a specific number of votes to overturn the results in Georgia. There it was. The statement that had been played on national news countless times. The words that had sparked congressional inquiries, federal investigations, and, ultimately, one of the most controversial cases in modern political history. The courtroom remained eerily still, all eyes on Reynolds. Trump finally moved, shifting forward slightly, his expression neutral but attentive. When he spoke, his voice was calm, but there was a sharpness to it. Ms. Reynolds, he said, interrupting before the prosecutor could continue, are you aware of how many fraudulent votes were found in Georgia after the election? The prosecutor's head snapped toward the judge. Your Honor, the defendant cannot cross-examine the witness directly. The judge raised a hand, silencing the interruption. He turned to Trump. Mr. Trump, you will have an opportunity to respond through your attorneys. Do not address the witness directly. Trump exhaled, shaking his head slightly. Fine, he muttered, leaning back again. The prosecutor returned his attention to Reynolds. Ms. Reynolds, did you feel pressured during that phone call? Another pause. Yes, she admitted. There was an implication that my refusal to act could lead to consequences. Trump let out a soft chuckle. He turned to his attorney, whispering something under his breath. His legal team remained composed, but there was tension in the air. They knew this was damning. The prosecutor stepped forward. Ms. Reynolds, in your professional opinion, was this phone call an appropriate exercise of presidential authority? She didn't hesitate this time. It was an attempt to interfere with the electoral process. The judge cleared his throat. The defense may now respond. Trump's lead attorney stood. A tall man with salt and pepper hair, he adjusted his tie before stepping forward. Ms. Reynolds, let's be precise, he began. Did the president ever explicitly tell you to fabricate votes? Reynolds hesitated. No, but he... The attorney raised a hand. Just a yes or no answer, please. No, she admitted. The attorney turned to the jury, letting the word settle in the air. Then, he continued. Did the president ever threaten you with any specific legal consequences? Reynolds exhaled. Not in direct terms, but... Thank you, Ms. Reynolds. The attorney turned back to the judge. No further questions at this time. Trump watched the exchange with satisfaction. The defense had done its job, planting just enough doubt to weaken the prosecution's narrative. The judge nodded. We will take a short recess before calling the next witness. As the gavel struck, the courtroom erupted into a low hum of conversation. Reporters hurried to take notes, analysts whispered to each other, and Trump turned to his legal team with a small smirk. This is nothing, he muttered. They've got nothing. But despite his bravado, the weight of the case was undeniable. The prosecution still had multiple witnesses, including former White House aides, intelligence officials, and legal analysts who had been directly involved in the events following the 2020 election. And each testimony brought the risk of something new, something unpredictable. As Trump stood, stretching his legs, he could already picture the headlines. Historic trial, former president tests limits of justice system, Trump on defense, will the law catch up to him? Or perhaps, if things went his way, political persecution exposed, Trump fights back against biased trial. It wasn't just a legal battle. It was a war for perception. And for Trump, perception had always been the most powerful weapon of all. Trump scoffed impatiently. So, your argument is that the law itself doesn't make sense? No, Mr. Prosecutor, Trump responded, his voice remaining level. My defense is that you don't even understand the law you are trying to enforce. A sudden silence filled the courtroom. The murmurs, the laughter, the dismissive glances, everything vanished. People had come expecting a show, a predictable fall from grace, but now they were listening. Even the judge, who had maintained an air of detached amusement, leaned forward slightly, his interest visibly piqued. Trump reached for a document from the pile on the table before him and flipped through it casually. The entire prosecution hinges on the idea that my actions violated certain regulations. But let's take a closer look at those regulations, shall we? He lifted several pages, holding them up for emphasis. This law was written decades ago, designed for an industry that bears little resemblance to the one we have today. The language is outdated, the structure inefficient, and worst of all, it contradicts itself in multiple places. The prosecutor shifted uncomfortably. His confidence, so solid a moment ago, wavered slightly. That's just rhetorical nonsense, he countered. Trump raised a single finger, gesturing for silence. Oh, really? Then let's apply some logic. He turned to another page, pointing at a section with his index finger. If I were to follow this statute to the letter, I would simultaneously be in violation of another federal mandate that requires an entirely different set of conditions. He flipped through a few more pages, highlighting the contradictions. So tell me, should I comply with this law or the one that directly opposes it? The judge, who had earlier entertained the proceedings with a condescending smirk, now wore a frown. Adjusting his glasses, he examined the sections Trump had referenced. His lips tightened. Laws, like physics, operate on principles, Trump continued. And principles cannot contradict each other. Yet this entire case is built on contradictions. A shift rippled through the jury, uncertainty. Trump sensed it and turned back to the prosecutor. You assumed I wouldn't understand this tangled mess of legislation. But I don't need obscure legal jargon to dismantle your case. I just need logic. The judge, who had earlier lounged in his chair, now tapped his fingers on the desk, no longer amused. Trump leaned forward, tapping the document as if emphasizing a key point in a business seminar. Your Honor, look at Section 42.3 of the law being used against me. Skeptical, the judge put his glasses back on and flipped to the indicated section. The prosecutor, sensing the tide shifting, hastily searched for his own copy, flipping through the pages with an urgency that betrayed his growing anxiety. This law, Trump continued, his voice calm and measured, was written before the internet as we know it even existed. How can you regulate something using rules designed for a world that didn't anticipate the present reality? A murmur swept through the courtroom. The judge's brow furrowed. The logic was undeniable. The prosecutor straightened, regaining some composure. Legal principles don't become obsolete simply because technology evolves. Trump arched an eyebrow. Are you sure about that? Because Section 43.1 directly contradicts the very basis of your accusation. He pulled out another document, running his finger along the underlined text. It states, and I quote, "If a technology exceeds existing regulations, a new set of rules must be established before penalizing the entity responsible for its development." The room fell into a tense silence. The judge's frown deepened as he read the passage. His lips parted slightly, as if considering the weight of what had just been revealed. The prosecutor paled. He had not prepared for this. For the first time in the trial, Trump was no longer on the defensive. He was dictating the pace. A bead of sweat formed on the prosecutor's temple as he fumbled for a counter-argument. That clause refers to new industries, not to pre-existing regulatory frameworks. Trump smirked. And yet, it doesn't specify that. Nowhere does it state that certain industries are exempt. Which means your entire case hinges on an interpretation, not on an indisputable fact. The judge sighed, rubbing his temple. He knew where this was heading. The defense attorney stood, stepping forward to capitalize on the moment. Your Honor, given this clear legal contradiction, we motion for an immediate dismissal of all charges. There is no legal basis for prosecution when the very law being cited undermines itself. The courtroom erupted. Reporters scrambled to take notes, legal analysts whispered furiously among themselves, and spectators exchanged wide-eyed glances. The prosecutor, grasping at straws, interjected. This is an absurd attempt to distort the law. The intent of the legislation is clear. Trump cut in. Intentions don't matter in a court of law, precedent does. Show me the case law where ambiguity is interpreted in favor of prosecution rather than defense. Silence. The prosecutor knew that no such precedent existed. The judge adjusted his glasses, staring hard at the documents before him. His fingers drummed against the wood. He looked at the jury, at the spectators, and then finally at Trump. I need to confer with legal experts before proceeding, he declared. This court will recess until further notice. The gavel struck. Trump leaned back in his chair, a small smile playing on his lips. He had done it. He had forced the system to question itself. As the room buzzed with speculation, one thing was clear. This trial was no longer just about Trump. It was about the law itself. About how justice should be applied in an era of unprecedented change. And for Trump, that was a battle worth fighting. Trump took a deep breath, his gaze steady as he looked toward the judge. Are we here to discuss supposed legal violations, or are we merely witnessing an attempt to punish innovation through outdated laws? The prosecutor opened his mouth as if to speak, but no words came. His lips trembled slightly, and the desperation in his eyes was evident. Trump, however, did not smirk in triumph. He didn't need to. He had already destabilized the foundation of the prosecution's entire argument. The judge exhaled heavily, rubbing his temples. What had started as a simple case of legal non-compliance had suddenly transformed into something far more complex. It was no longer about Trump alone, it was about the clash between technological evolution and the rigidity of the legal system. For years, the legal framework had struggled to keep pace with the rapid advancements in business and technology. Now, in the midst of this courtroom, that struggle was laid bare. The judge had entered this trial believing Trump to be just another powerful figure attempting to circumvent the law. But now, that assumption was crumbling. The clarity with which the defendant exposed the contradictions in the legal system was both unsettling and undeniable. Trump picked up a thick volume of documents from the table before him. His movements were slow and deliberate, as if he were delivering the final blow. Your Honor, he continued, flipping through the pages. It is also important to consider precedent. In the case of Smith versus V Tech Corp., which was tried in this very court, the ruling was clear. No company or individual can be penalized for operating in legal gray areas when legislation has failed to keep up with progress. The judge pressed his lips together, narrowing his eyes as he tried to recall the case. Yes, he vaguely remembered it. The ruling had established that ambiguity in the law could not be used as grounds for prosecution. But the prosecutor, now visibly sweating, scrambled through his own papers, desperately searching for a counter-argument. Trump delivered the final strike. And so, I ask, he said, his voice measured but cutting. Is this hearing truly about justice, or is it merely an effort to punish progress that does not conform to outdated rules? Tension spread through the room like a wave. The judge, who had previously seemed assured of the prosecution's case, now found himself in a dilemma. The arguments he had expected to hold firm were unraveling before his eyes. The prosecutor, realizing his case was slipping through his fingers, grasped at one final attempt to regain control. Your Honor, he said, stepping forward and holding up a thick stack of documents. We have new evidence. There was a collective intake of breath from the gallery. This dossier, the prosecutor continued, his voice rising with a newfound urgency. contains proof that the defendant knowingly violated regulations. It's all here, detailed and documented. Trump did not flinch. He simply crossed his arms, his expression unreadable. The judge arched an eyebrow as he took the dossier, flipping through its pages. After a few moments, he looked up at Trump. "Mr. Trump," he said, his voice firm but curious, "do you have anything to say regarding this material?" Trump leaned forward slightly, his response as calm as ever. "Of course, Your Honor," he said smoothly. "It is quite interesting how this report has suddenly surfaced, especially since it was written after this trial had already begun." A murmur spread through the courtroom. If this evidence had been so critical to the prosecution's case, why had it not been presented earlier? Trump let the silence settle before continuing. "If this report was so essential to the charges against me, why wasn't it included from the beginning? This isn't evidence, it's an afterthought. A last-minute attempt to plug the holes in a case that is already sinking." The judge slowly turned his gaze toward the prosecutor, waiting for an explanation that never came. The prosecutor's face drained of color. Trump leaned back, allowing himself a small smile. "Desperation is not a legal strategy, counselor. It is simply desperation." The atmosphere in the courtroom thickened, almost suffocating in its weight. For the first time, it was no longer just about whether Trump was guilty or innocent. The perception in the room had shifted. He was no longer merely defending himself. He was winning. Silence reigned as the judge drummed his fingers on the armrest of his chair, deep in thought. The prosecutor stared down at the floor, seeming momentarily lost. Trump glanced at his legal team, who remained composed, though there was an unmistakable air of satisfaction among them. The judge finally broke the silence. "We will take a brief recess," he declared, bringing down the gavel. "Court will reconvene in 30 minutes. As the spectators began to murmur and the press scrambled to jot down the latest developments, Trump rose from his seat. He adjusted his suit jacket and turned to his attorneys. "This was supposed to be their strongest argument," he muttered. "And now it's a joke." His lead counsel nodded. "They were relying on a strategy of intimidation, but now, they've lost credibility." Trump smirked. "Then let's make sure they don't get it back." Outside the courtroom, the world was already reacting. News outlets dissected every moment of the trial, analysts debated the implications of Trump's argument, and social media was ablaze with speculation. Some hailed him as a defender of innovation, exposing the flaws in an antiquated legal system. Others condemned him, arguing that he was manipulating technicalities to escape accountability. But regardless of perspective, one thing was certain: this trial had become more than just a legal battle. It had become a referendum on the system itself. And Trump, as always, was at the center of it. Trump rested his hands on the table, his expression calm and composed, as if he had already foreseen the inevitable. The air in the courtroom was dense with anticipation. The judge, after what felt like an eternity of silence, inhaled deeply before speaking. "Mr. Trump," he began, his voice carrying a mix of surprise and reluctant admiration. "I must admit, I underestimated you." A ripple of murmurs spread through the courtroom. The spectators, who had initially been convinced of Trump's impending conviction, now exchanged uncertain glances. The prosecutor stood frozen, his face pale with disbelief. The judge continued. "When I entered this courtroom, I was certain that your actions were unlawful and reckless. But after the arguments presented today, I see that the foundation of this prosecution is weak, if not entirely flawed." The silence in the room deepened, broken only by the faint scratching of reporters hastily taking notes. "The defendant has not only dismantled the case against him," the judge went on, "but he has also exposed inconsistencies in how this case was built. The evidence presented by the prosecution has, at the very least, proven to be questionable, and in some instances, even misleading." The prosecutor swallowed hard, his hands trembling as he flipped through his notes. He had come into this trial confident, even arrogant. But now, as he stood before the judge, he found himself struggling for words. Then, the final blow came. "I find no reason to continue this trial. Mr. Trump, you are free to go." A collective gasp echoed through the room. Some in the audience shook their heads in disbelief, others nodded slowly, as if trying to process what had just happened. The prosecutor, visibly shaken, attempted to raise an objection. His lips parted slightly, but no words came out. His arguments, his entire case, had been systematically dismantled. Trump allowed himself a small, knowing smile. He had seen this result coming from the moment he took his seat, observing every reaction, analyzing every weakness. The courtroom began to empty, but the repercussions of what had just transpired would extend far beyond its walls. Outside, a storm of reporters had gathered, microphones raised, cameras flashing from every direction. The intensity of the crowd was overwhelming, voices overlapping as journalists tried to get the first soundbite. A reporter, holding a recorder high above the crowd, shouted, "Mr. Trump, how do you feel about your victory?" With a half smile, Trump slid on his sunglasses and replied, "I think logic did its job." The statement spread like wildfire. Within minutes, headlines flashed across news channels and social media platforms. Trump defies the system and walks free. The former president outmaneuvers the Justice Department. Legal genius or master manipulator? Trump reshapes legal precedents. But the impact extended beyond the immediate media frenzy. Legal experts began dissecting the trial, debating the structural weaknesses in the judicial system that Trump's arguments had exposed. Professors in law schools added the case to their curricula, analyzing how the defense had turned an allegedly airtight case into an example of legal ambiguity. Corporate attorneys, once confident in their conventional legal strategies, started reviewing similar cases, recognizing that their methodologies might not be as infallible as they had once believed. In the days that followed, analysts debated whether the ruling was a victory for justice or a dangerous precedent for the future. Some argued that Trump had exposed the flaws in a rigid legal system, proving that laws must evolve with the times. Others feared that his acquittal demonstrated how power and influence could bend the justice system in favor of the elite. The judge, who had initially dismissed Trump's defense as mere theatrics, later admitted in an interview, "He didn't just defend himself, he forced us to reassess the very foundation of the law." Meanwhile, Trump simply moved on. To him, this was just another day, another obstacle overcome, another system challenged and forced to adapt. Another Tuesday. Another moment where the establishment had no choice but to acknowledge his influence. The courtroom was now empty, but the echoes of what had transpired lingered. The judge, leaning back in his chair, tapped his fingers against the armrest, deep in thought. He had always believed in the sanctity of the law, in the idea that the courtroom was the ultimate authority. But today, he had witnessed something unexpected. An outsider, a non-lawyer, dismantling an entire prosecution using nothing but logic and strategy. Trump had not only won his case. He had reshaped the conversation around justice itself. Even his critics were forced to acknowledge his ability to turn adversity into an opportunity. The political ramifications were immediate. His supporters hailed the trial as proof that he had been unfairly targeted by a corrupt system. His opponents, on the other hand, saw it as further evidence of his ability to evade consequences. Social media exploded with reactions, some celebrating his acquittal, others condemning it. One post, which quickly went viral, summed it up succinctly. "Love him or hate him, you can't ignore him." And that, in the end, was exactly how Trump wanted it. No longer just a trial, no longer just a legal battle. This was history in the making. And Trump, as always, was at the center of it. Trump's trial had proven something much larger than just his own innocence. By applying principles of strategy, logic, and an almost engineering-like approach to dismantling legal accusations, he had demonstrated that complex problems required creative solutions. But an inevitable question remained. How many cases had already been decided unfairly simply because those challenging the system lacked the resources to expose its internal flaws? Trump's victory was not just personal, it was merely the tip of an iceberg that revealed a much broader debate. Law, like science and technology, must evolve. The verdict had been announced, but the echoes of that discussion would continue to reverberate. To what extent could legislation, conceived in past eras, truly address realities that were evolving at an unprecedented pace? Trump had shaken that structure, forcing a reconsideration of outdated legal frameworks. If one person could prove that the existing rules were obsolete, wasn't it time to rewrite them? In the end, this trial had become more than just a legal battle. It had become a symbol of resistance against outdated norms. In the hallways of the courthouse, seasoned attorneys were already discussing the need to rethink legal strategies and adopt more flexible approaches. Some of the more traditional voices still argued that the law should remain as it is. That it was the only thing keeping order in society. But an undeniable truth lingered in the air. The contradictions exposed in that courtroom could no longer be ignored. In the days that followed, Trump remained relatively silent about the legal aspects of his case. He refrained from dwelling on the technicalities of his defense and instead focused on what truly interested him, moving forward, reshaping public perception, and continuing to challenge the structures that sought to constrain him. Yet, while he personally left the details behind, experts from various fields launched an intense public debate. Where was the line between breaking barriers and breaking the rules? Should the law adapt to new technological and societal developments, or should it regulate every new phenomenon with strict control? And most importantly, How many people had lost similar battles simply because they lacked the resources to expose the gaps in the system? The impact of this case stretched far beyond newspaper opinion columns. Heated discussions erupted in online forums, talk shows, and political circles. Some dismissed Trump as arrogant. Others called him a visionary. Some argued that justice had been served. Others claimed that he had walked free only because he was a billionaire with access to the best legal minds. Ironically, however, Trump had dismantled the prosecution's case almost entirely by himself. For the judge, who had once treated the defense's arguments with sarcasm and amusement, this case had turned into a bitter yet transformative lesson. The humiliation he had expected Trump to endure had, in the end, backfired, exposing just how fragile and misaligned many of the laws that were once considered solid actually were. In a rare moment of self-reflection, the judge later admitted in an interview, "Justice is not a simple equation." Trump had left the courtroom victorious, but the storm he had set in motion was far from over. Legal scholars began re-evaluating cases that relied on outdated precedents. Law schools introduced new discussions about the need for reform in legislative processes. Some called for immediate updates to existing regulations, arguing that the law must reflect the realities of the modern world rather than remain chained to interpretations from decades past. Others pushed back, insisting that legal stability was more important than constant adaptation. Meanwhile, in the political arena, the fallout from the trial was enormous. Trump's supporters celebrated the verdict as proof that he had been unfairly targeted by a biased system. They hailed him as a warrior against corruption, a symbol of resilience against political persecution. His opponents, however, saw the ruling as a dangerous precedent, proof that the justice system had failed in its duty to hold the powerful accountable. A few moderates, caught between these two extremes, found themselves grappling with a more complex question. Had Trump won because he was truly innocent? Or had he won because he understood the system better than those who sought to bring him down? Social media exploded with reactions. One particularly viral post summarized the sentiment of the divided public. Whether you love him or hate him, you can't ignore him. As Trump continued his post-trial appearances, his confidence was unshaken. He knew that beyond the legal victory, he had achieved something much more significant. He had changed the conversation itself. His presence at rallies, on television interviews, and across media platforms reinforced the idea that he was more than just a politician or a businessman. He was, in the eyes of many, a force of disruption. Not a man who played by the rules, but one who forced the world to rethink them. He had confronted the legal system, not just as a defendant, but as someone who demanded answers to questions that few had dared to ask. The battle had been fought in the courtroom, but the war over legal interpretations and political power had only just begun. For Trump, this was nothing new. It was just another chapter in his long history of challenging the establishment. Another fight. Another victory. Another moment where he had forced the world to pay attention. And as the legal and political landscapes continued to shift, one thing remained certain. Donald Trump was not going anywhere. His influence, love it or hate it, was now more undeniable than ever. In certain cases, justice depends on acknowledging that the legal system, as rigid and authoritative as it may seem, is not infallible. Recognizing this truth was already a step forward. But another fundamental question remained. What happens when innovators do not have a voice? What happens when someone without fame, without wealth, without influence encounters contradictory laws that prevent them from pursuing their business, their project, or even their most basic freedoms? Would that person have the same opportunity to challenge those legal inconsistencies? This was the discussion that began to gain momentum in the weeks following Trump's trial. An initial push to reassess outdated laws emerged across multiple sectors, laws that had failed to keep up with the digital age, with space exploration, with advancements in energy production. Whether these discussions would lead to meaningful legal reform was another matter entirely. But one thing was clear, the precedent had been set. What was supposed to be a trial condemning an arrogant businessman had transformed into a public showcase of the obsolescence of certain legal frameworks. The media narrative shifted. The headlines no longer simply read Trump acquitted, but instead outdated laws under review, who will challenge the system next? In talk shows and panel discussions, lawyers and legislators debated the issue night after night. Some insisted that the structure of the legal system must remain untouchable, that exceptions could not be made for individuals, no matter how powerful or innovative. Others, more pragmatic, argued that modernization was necessary, that refusing to update the law would only serve to stifle innovation and give an unfair advantage to those with the resources to manipulate legal loopholes to their benefit. In the midst of this turbulence, Trump carried on with his routine, seemingly unaffected by the legal and political storm he had triggered. When questioned about the case, he responded with his signature simplicity. I followed the logical path. When laws contradict each other, you have to question them. You don't just blindly follow something that doesn't make sense. His words sparked mixed reactions. To some, his statement was arrogant. To others, it was clarity. But the conclusion was not as simple as either side wanted it to be. Even the judge, who had initially dismissed Trump's arguments with sarcasm, later admitted to reporters, if we had scrutinized the law more thoroughly from the start, maybe we could have avoided this public embarrassment. It was as if he knew exactly where the cracks were. He simply had to point them out. And so, a trial that had begun as an ordinary legal proceeding, expected to conclude swiftly, had instead become a landmark moment in judicial history. Weeks later, a major television network aired a special investigative report on the case. The program featured key moments from the trial, expert commentary, and, in the final segment, left viewers with an open-ended reflection. How many other laws still in force today were written for a world that no longer exists? How often do we accept rules simply because they have always been there? Online forums erupted in debate. The discussion had now moved beyond Trump himself. People were questioning the very foundation of legal interpretation. Some argued that the system was overdue for a complete overhaul, while others feared that constantly revising laws could lead to instability and unpredictability. But no matter which side of the debate one stood on, there was no denying that the trial had exposed something deep and unsettling. Trump had not just walked free. He had forced the world to take a hard look at the justice system itself. For his supporters, this was proof of his brilliance. For his detractors, it was proof of his ability to manipulate the system. For legal scholars, it was a moment that demanded serious reflection. In the political sphere, the trial's impact was seismic. Trump's victory reinvigorated his base, fueling a narrative that he had been the victim of an unfair, politically motivated witch hunt. His rallies took on a new energy, his speeches filled with declarations of triumph over a corrupt establishment. His opponents, meanwhile, scrambled to counter the growing perception that the justice system had failed to hold him accountable. But the legal world was now grappling with an even bigger dilemma. If Trump could expose contradictions in the law and successfully use them to his advantage, what would stop others from doing the same? Was the legal system strong enough to withstand challenges from individuals who understood its weaknesses? Would lawmakers step up to close the gaps, or would they continue to rely on outdated regulations? There was no clear answer. But one thing was certain. This case would be studied for years to come. Professors began integrating the trial into their law school curricula, using it as a case study in legal interpretation, judicial overreach, and the need for legislative reform. Corporate lawyers, many of whom had long relied on bureaucratic red tape to control competition, suddenly found themselves reassessing their strategies. Government agencies tasked with regulatory enforcement realized they had to modernize their approach or risk further legal challenges. The ripple effects extended far beyond Washington, reaching boardrooms, law firms, and courtrooms across the country. And yet, through it all, Trump remained unfazed. He had won. He had turned what was meant to be his downfall into one of his greatest victories. And, more importantly, he had ensured that his name would remain at the center of national debate, not just as a politician or a businessman, but as a disruptor of the system itself. His critics fumed. His supporters cheered. And the world watched. Because whether people loved him or hated him, one truth remained undeniable. Donald Trump had once again redefined the rules of the game. Should the law behave like technology, constantly evolving and adapting to new realities? Or should it remain an unshakable foundation, providing security and predictability for society? The debate was far from settled. Some argued that laws must be immutable, an unwavering pillar upon which civilization rests. Stability, they claimed, was paramount. Without it, chaos would reign. Others countered that stability should not mean paralysis. Every system must include mechanisms for revision, correction, and improvement. Without flexibility, the legal framework itself could become an obstacle to progress. And in the center of this debate stood Donald Trump. After his shocking courtroom victory, his focus had seemingly already shifted to the next campaign, the next legal battle, the next media storm. He was a man who never stood still, who never let one moment define him for too long. Yet, his exit from the courthouse, sunglasses on, delivering a single confident remark, had become an instant cultural moment. Looks like logic did its job. The phrase spread like wildfire. It became a meme, used both mockingly and admiringly. It was printed on t-shirts, quoted in political arguments, and dissected by analysts searching for a deeper meaning. But beyond the humor, beyond the internet's fascination with his defiance, a much larger question loomed. If logic, critical reasoning, and systematic analysis are the cornerstones of any legal proceeding, why had it taken a non-lawyer, a businessman, to expose contradictions that experienced legal professionals should have recognized? Trump's victory had highlighted something far more profound than his own innocence. The case had revealed an unsettling reality about the justice system itself. If one individual, through sheer scrutiny, could dismantle an entire prosecution by pointing out inconsistencies, then perhaps the foundations of the legal system were not as solid as people had long assumed. And yet, another uncomfortable truth emerged in parallel. Not everyone would have the same opportunity to challenge the law. Trump, with his influence, wealth, and relentless media presence, had been given the space to speak. He had the resources to fight back rather than be silenced. But what about those who lacked such advantages? How many individuals had faced similar legal contradictions but never had the means to expose them? How many people had been convicted under equally flawed arguments but lacked the ability to question the laws that bound them? One of the judge's final remarks, recorded in an interview after the courtroom had emptied, carried a rare moment of self-reflection. We have always assumed that the law is absolute and flawless. But we forget that it was written by people, in a specific time and context. And when reality shifts, the law sometimes fails to keep up. And there stood Donald Trump, winning his case precisely in that gap, in that undefined space where legal traditions struggle to account for modern complexities. In that same interview, the judge continued, his tone more thoughtful than authoritative. Perhaps we truly do need different kinds of minds, from outside the legal profession, to help us see the cracks in what we have always assumed to be unquestionable. And so, this was no longer just the story of a billionaire walking free from a highly publicized trial. It was a story about how one person, regardless of their background, could hold up a mirror to an entire system, exposing its inconsistencies, its outdated rules, and the fundamental need for reform. It was about the realization that even institutions designed to ensure fairness were not immune to scrutiny. In the following weeks, debates erupted across political, academic, and legal circles. Did this trial prove that the justice system needed urgent reform? Or had it merely demonstrated that those with power and resources would always find a way to bend the law to their advantage? There was no universal consensus. Legal scholars organized panels dissecting the trial, questioning whether Trump's defense had revealed structural weaknesses in the legal framework or if it had simply been an example of legal strategy at its most effective. Professors in law schools assigned new coursework based on the case, challenging students to examine the implications of legal contradictions and judicial overreach. Corporate attorneys, many of whom had built careers navigating bureaucratic loopholes, suddenly found themselves reassessing their strategies, realizing that what had happened in that courtroom could easily happen again. Meanwhile, in the political arena, the trial's impact was seismic. Trump's supporters celebrated the verdict as proof that he had been the target of an unjust, politically motivated attack. His rallies swelled with energy, filled with chants about defeating corruption and standing against a rigged system. His opponents, on the other hand, sounded the alarm. To them, this was a dangerous precedent. It was evidence that power, when wielded skillfully, could turn even the justice system into a battlefield where legal technicalities outweighed accountability. Yet, no matter how divided the responses were, one undeniable fact remained. Trump had changed the game. Beyond the immediate ramifications, the case had set a precedent in legal discourse, one that would be analyzed and debated for years to come. Some feared that it would embolden others to challenge established legal precedents, creating chaos within the justice system. Others saw it as a necessary disruption, a wake-up call forcing lawmakers to modernize outdated regulations and close glaring legal loopholes. But for Trump himself, the details of the debate were secondary. He had won. He had taken what was supposed to be his downfall and turned it into a triumph. One that extended far beyond the walls of the courtroom. And now, he was moving forward, onto the next challenge, the next controversy, the next opportunity to redefine the rules in his favor. Because if there was one thing his career had proven, it was that Donald Trump never simply played by the rules. He forced the world to reconsider them. What would we do with this realization? Would we rewrite the laws, or would we leave everything as it was? Months after the trial, the debate still raged in academic and political circles. Proposals for legal reform surfaced in various places, yet as always, the legislative process moved at a sluggish pace. When asked about the issue, Trump rarely entertained the discussion. His response remained consistent. If innovation doesn't fit within the law, should the law change? Or should innovation be forced to stop? This question, posed in interviews and echoed across social media, fueled an intense polarization of opinions. Some viewed Trump's trial as a stark warning, a sign that legal frameworks were outdated and needed urgent modernization. Others argued that tradition, even with its imperfections, provided the necessary stability to prevent chaos. The case of Trump versus the legal system was officially closed that afternoon when the judge read the verdict and dismissed the defendant with a subtle nod. But in reality, it remained very much alive in public discourse. It served as a constant reminder that gaps, contradictions, and legal loopholes existed even in the most revered institutions. Perhaps that was the trial's greatest lesson. Laws, much like technology, could not afford to remain frozen in time. And so, the question persisted. Should legislation adapt to the rapid pace of technological and societal change, or should it stand firm, providing a foundation that, while imperfect, ensured stability? One thing was undeniable. Trump's case had ignited a conversation that was far from over. If a single courtroom battle had raised so many uncertainties, one could only imagine what might happen when other disruptive minds challenged the existing order. After all, the conversation had only just begun. Life, much like the world around us, is in a constant state of change. As we grow older, we often reflect on the traditions, values, and systems that have shaped our lives. We take comfort in stability, in the idea that some things should remain as they always were. But is stability always the answer, or is there wisdom in adapting to change? One of the most profound lessons from history is that no system, whether legal, technological, or societal, can remain frozen in time. We have seen industries transform, laws evolve, and cultures shift. The world of today is vastly different from the one we were born into, and the rate of change is only accelerating. Yet, as unsettling as this can be, resisting change is not the solution. Instead, embracing it with understanding and wisdom is the key to staying engaged, relevant, and fulfilled. In every aspect of life, adaptation is necessary. Our health, relationships, and communities all require us to adjust. Just as laws must be revised to reflect modern realities, so too must we be willing to update our perspectives. Learning new skills, exploring fresh ideas, and even rethinking long-held beliefs can lead to a richer, more meaningful life. One of the greatest strengths of older generations is their wealth of experience. While younger generations bring innovation and new ways of thinking, it is those with wisdom who can provide guidance, context, and a sense of continuity. Change does not mean discarding the past, it means using it as a foundation to build a better future. So, how do we apply this lesson to our daily lives? First, we must cultivate a mindset of lifelong learning. The world may be shifting rapidly, but knowledge is more accessible than ever. Whether it's keeping up with technology, understanding new social dynamics, or even picking up a new hobby, staying curious keeps the mind sharp and engaged. Second, we should embrace open conversations. Listening to different perspectives, even those we might initially disagree with, allows us to grow. It fosters understanding and helps bridge generational divides. Finally, we must recognize that change is not something to fear but something to guide. The experiences of a lifetime grant us the wisdom to help shape progress in a way that respects the past while embracing the future. At its core, life is not about resisting change, but about learning how to navigate it with grace and purpose. By doing so, we not only enrich our own lives but also leave behind a legacy of wisdom for those who follow.